and everything. And a very big special thank you to Larry, who chaired 2 meetings in my absence, and I think did a phenomenal job. And, you all got a huge amount done while I was in the hospital. So thanks so much to everybody.
Here. Yep.
I'm also very excited to welcome Lisa Pina, who is our new planning board clerk.
Woo-hoo.
This is very, very exciting. Lisa will be taking minutes at our meetings moving forward and working with the board to ensure that our agenda and minutes and project materials are all posted and accessible to the public. Yeah, we're so happy to have you, Lisa.
Thank you. I'm glad to be here.
Welcome, Lisa.
Thank you.
Everybody.
Welcome aboard.
Thanks.
All right. So before we dive in, any questions or comments from the board, I guess, before we jump into the agenda? All right, then let's go into our first item. So this is the planning board is going to consider a resolution for a settlement agreement with Bell Atlantic Mobile Systems, DBA Verizon Wireless. As you all know, we previously approved a special use permit for Verizon to install telecom equipment at 119 Columbia Street. There was a lawsuit, and there is now a settlement agreement. As a starting point, we need to do an attorney-client session with Mr. David Luntz, who is the attorney that represented the city in this settlement matter. Our aim is not to spend a long time in this session and jump back into the meeting, but we're going to need 10 or 15 minutes just to go through everything with David, and then we'll rejoin the meeting to review the resolution. So, Shaheen, could you create a breakout room for members of the board and Mr. Luntz?
We're all set.
And Victoria? All right, thanks everybody. Should I go ahead and pull up the resolution so we can read through that and then review? Let's see. Let me make sure I've got the right thing here. That is not what I need. Hold on. Okay. There we go. All right, does everybody see that? Victoria, I mean, do you think we just read through this and then?
Yeah, I would just read through it and then ask if anyone has questions, and then you have a motion to adopt it, if that's what the board wants to do.
Okay. All right, so a resolution to approve a settlement of litigation with Verizon Wireless and amend the special use permit and site plan approval. Whereas on June 23rd, 2021, the planning board adopted a resolution which granted site plan approval and a special use permit to Verizon Wireless for a telecommunications facility at 119 Columbia Street. And whereas Verizon Wireless filed a lawsuit in federal court against the city of Hudson and the planning board, challenging various elements of the June 23rd resolution and seeking other relief against the city. And whereas the city retained independent counsel to represent the city defendants in the lawsuit, whereas counsel has presented a proposed stipulation and order that resolves the action without the need for further litigation, without any admission as to the merits of the respective parties' positions in the litigation, and without the city requesting any additional escrow fees from Verizon Wireless or having to refund any escrow fees to Verizon Wireless. Now, therefore, let it be resolved that the planning board approves of the stipulation and order in the above referenced action and authorizes execution on its behalf. And let it be further resolved that provided the Hudson Common Council approves the stipulation and order, which it has, the June 23rd, 2021 resolution is hereby amended as follows. Condition 2 of the second be it further resolved clause contained in the resolution related to a deed restriction is hereby deleted in its entirety. Condition 3 of the second be it further resolved clause contained in the resolution is hereby revised and amended to confirm that the note to be added to sheet C2 of the site plan shall state that the applicant shall return to the planning board for approval of any modification of the facility pursuant to section 284-5A of the city code. It is acknowledged and understood by all parties that a modification in the technology employed at the property, which changes the service from 4G to 5G, does not require approval by the planning board as long as any new or modified antennas continue to be screened by the approved stealth concealment panels. Condition 5 of the second be it further resolved clause contained in the resolution is hereby amended to provide that the approval required by said condition 5 shall be granted within 30 days of submission by Verizon Wireless of all required information. And I believe that last one is about sharing the final plans for the stealthing. So we'll have 30 days to review that. All right, board, any questions or comments about this resolution?
I have one comment or question. So just so we're clear, there is a federal co-location requirement, right? So if indeed, because we don't have the deed restriction, which I understand, that means that other carriers have the right to locate their equipment on top of Providence Hall. Can you just talk us through, maybe Victoria, the mechanism for that? Will they need to come before the board at all for that? Can we include new carriers' antennae inside the existing screening that Verizon will build, or can we require additional screening for any new carriers? Or are we going to wind up inevitably now with the very thing that we were trying to do, which was to avoid the rooftop of Providence Hall looking and functioning like, say, the roof of the hospital?
So David, you might be able to speak to the federal co-location requirement better than I can. But the way this reads is that they have to comply with our code, and our code does require site plan approval for new telecommunications equipment. So if it's not contained within the stealthing as shown on the site plan, they're going to have to come back to the board.
I understand Verizon would, but if AT&T comes to us and says you already have equipment on Providence Hall, then that was the whole point of the deed restriction, right? Was to try to limit the clustering of antennae on top of the roof. And I just want to know, we may have no choice here, but I do want to know, and I want the public to know what's being conceded here, if anything.
David, can you answer that question?
Sure. Yeah, my understanding is that if there is another provider who seeks to use the roof of this building, they would have to come before the board with a separate application. This special use authorization only relates to Verizon Wireless.
Know that, but there's also a law that says that once one provider is up there, you cannot refuse another provider. Is that correct?
Well, that doesn't mean they wouldn't have to file an application.
Right, but
And each application stands on its own merits.
But isn't there, I'm simply asking, I think what in response to what Larry said, from what we understand, another provider could come to the planning board and we cannot refuse them the ability to have their equipment up on the building because federal law says so. Is that true?
I can't answer that question based on, without seeing an application in front of me for a particular provider, I can't answer that question.
So David, this would not prevent the board from reviewing a new co-location application to determine if it's appropriately stealthed this to the same level as this one is.
Correct. And any other concerns that might be within the planning board's authority.
Understood. Thank you.
Board, any other questions? All right. Does someone want to make a motion to adopt the resolution?
Yeah, I will. Yes.
Thank you. We have a second.
I'll second.
All right. Thank you, John. All right. Larry.
Yes.
Laura.
No.
Clark.
Yes.
John.
Yes.
Teresa.
No.
No. Jean.
Yes.
All right. I also vote yes. All right. All right. Well, thanks, David, for joining us. Appreciate your time. And we will file this resolution with the city clerk tomorrow.
Okay, thank you.
Thank you.
All right. All right, next up is 175 South Front Street, conditional use permit applications and site plans from Akal Russo and Son for road improvements and commercial dock operations. All right, so where are we? Basically, the board has been working through secret parts 2 and 3 over a number of months, and we've now completed our review basically and have posted final drafts as parts 2 and parts 3 on the city website and shared those with the applicants. So, you know, tonight we have a resolution to review a determination of significance for a positive declaration on this application. Although before we get into reviewing that resolution, I think that Mr. Privatera might want to make a statement to the board. Are you here?
I had a quick procedural, sorry, I just had a quick procedural question. Do we need to vote to accept or approve parts 2 and 3, like call them done, or is the simple posting of them equivalent to calling them done?
It's a good question, Larry. As I understand it, Victoria can speak to this actually, but my understanding is that we will be adopting, the entire, all parts of the seeker review basically and the resolution tonight, basically.
Okay, so the vote,
I should ask too. I don't want to rush through this by any means, but if the board has any questions or comments about anything in part 2 or part 3, definitely bring that up before we jump into the resolution too.
Can we do that now, Steve? I just have a couple.
Yeah.
I know we've been through this only 100 times, but my last review, and I know it's a draft, I have just several small, but I think important edits. And they're brief. And if I could mention those now, is this the appropriate time?
I think so. Yeah. I mean, are they I think we have an opportunity to make like tweaks and things like that to like language and stuff that needs to be fixed up. But these are substantive items that you want to talk about.
They're minor, but I think they're important. I can just mention them. We mentioned 195% increase, and we use presumed 195. And my look at it is that we don't use it throughout. So I'm just saying I have some page numbers where it's not used to modify 195. So I'm just suggesting that we use that consistently throughout. And I can mention the pages 7 on the bottom. Oh wait, sorry, it's not page 7. Pages 16 in the middle. Page 16 under, I apologize, under impacts on transportation. Page 15, the first paragraph, and noise and odor, and I believe that's it. And then one more. Again,
Clark, just to clarify, that's 3 locations that you know?
Yes, that I flagged them with my sticky tabs here. I'm checking my sticky tabs. I got page 16 under energy, 2 of them there, actually, one under the previous section. Sorry, let me just double check all this again. The second to last paragraph under transportation, the second paragraph under energy. Oh, sorry, the first paragraph under energy, and then the first paragraph under noise and odor and light. And I believe that's it. And then this relates to second, again, minor edit, but I think it's important. On page 7, I know in the past, previous conversation, we sort of struck language that wasn't in the part 2. So on page 7 at the bottom, we use dramatic increase in truck traffic. I know that's a qualifier, but I realized, Ryan, we had talked about using stark as a modifier. So perhaps that's best to use there and include it as well.
Hey, Clark, so I think we were trying to, as I recall, like echo the language in part 2, right? Which is stark the word that's used? And
no, sharp.
And it's in terms of community character, not.
Yeah,
so
that's
maybe,
true.
Maybe my suggestion is to strike that dramatic in that section.
Strike the word dramatic, basically. Just it's an increase.
It's an increase, yeah. So the modifiers a bit editorializing, we want to avoid that. And then lastly, in consistent with community character, and I just caught this in this last read, we mentioned, and this is the on that page, the second bottom paragraph, the planning board notes that the impacts include potential benefits to community character, particularly if the proposed project results in aggregate laden trucks no longer running on city streets. We make the point that this project doesn't relate to aggregate laden trucks on city streets. So I would just note that I would just strike in that sentence the proposed project, to change it to particularly if aggregate laden trucks no longer run on city streets. Does that make sense? Ryan?
Yeah, so we're striking from the proposed project. So particularly if
aggregate laden trucks no longer run on city streets, changing the running to run. Again, just like making it consistent with our other comments regarding the truck issue. Not to confuse the reader that this project is related to removing trucks from the city streets. And that's it.
Ryan, did you get all, I mean, I noted those down, everything that Clark said, but were you able to make those changes on the fly there?
I've made a number of them here. I can share my screen if you would like. So we'll turn on track changes here. So first item is to strike the word dramatic on page 7. So the sentence reading, concluding, and ability to sustain an increase in truck traffic as opposed to a dramatic increase. We added presumed with the presumed 195% increase in annual truck trips to impacts on energy. And at the end of the transportation section, those were 2 locations, Clark. Still, I was scrolling through to find the others. And then in community character, striking a couple terms here. So the sentence now reads, the planning board notes that the impacts include potential benefits to community character, particularly if aggregate laden trucks no longer run on city streets in the 2nd and 4th wards. So I know there were at least another couple locations to add in presumed. So I will make sure those get done. I can do that right on the screen if you would like right now. I think that was 15 and 7, right, Clark? I'm sorry to ask you again.
Well, yeah, sorry, no, it's good. It's all good. 15, page 17. I don't know if you caught that one. First paragraph on the odor, noise, light. There's a no 95 there. Yep. And that's the ones that I caught.
All right, thank you, Clark.
Sure.
Does anybody else have anything on part 3 that they want to note or change? All right. And I guess
Also, I was also going to note that part 2 was updated from the board's last discussion. The engineer went through and, took out some of the draft comments and finalized it. And that, as part of the vote tonight, it will be incorporating that part 2 as the board's final document.
Yeah, thank you. Yeah, and I suppose, maybe the most significant change in part 2 is that we answered in the plants and animals question, like for questions A through D, we changed those to moderate to large impacts, mostly with, the reasoning is explained in part 3, but essentially without information about the culverts, we see the potential basically for a moderate to large impact. I think we will be looking in the next step of this process to get that information on the culverts, basically. And actually, I should say now too, just I think, the board has been working extremely hard on every part of parts 2 and part 3, and we've been working closely with Victoria, our attorney, and our engineer Ryan to finalize all the language here and get their review on everything as well. So I think at this point we're feeling pretty good about the state of parts 2 and part 3, basically. But anyone else, if you have anything else to call out or change here, this is the time. All right, should we take a look at the resolution? You want to pull that up, Victoria?
Steve, I thought you were going to give Mr. Privatera a chance to.
Oh,
speak.
I forgot. You're right. Yeah, Mr. Privatera, are you here?
Yes, I'm here. I certainly, having just received this and having not seen the purported rewrite of part 1 that's referenced, we're not able to comment on this, and certainly I trust you don't want me to go through everything here. I just had a request as to why, after having this for 4 years, almost 5, why you're only giving us 7 weeks, with a couple of them being holiday weeks, to produce a scoping document, because nothing in the regulations requires anything that fast. So I had asked, a few minutes ago, I asked Victoria if we could have 60 more days.
All right, thank you. Yeah, no, we would be happy to consider that. I mean, I've been, seeing in the media complaints from the applicant about the pace of the process. I mean, it's worth noting, I think, in those 5 years that probably 1.5 years was lost in lawsuits challenging our right to do the secret review. But regardless, we are happy to consider that. I mean, do you want an extra 60 days? That's what you'd be requesting?
Yes, sir.
All right. So we can discuss that, I think, in the context of the resolution then, because we have a date in there for at some point in January, I think, right, Victoria?
Yeah, I think it says January 10th, and he's requesting that we change it to March 10th. I mean, just for the board's edification, the reason I included a date was twofold. One, to show that the board was eager to move this forward and start going through the process. And two, because the seeker regulations direct that when you adopt a positive declaration and you conduct scoping, you give the public notice of how scoping is going to be conducted, how and when. And so providing a date was to also help the public have notification of when to start looking for that draft scope so they can begin commenting on it. So there's no formal deadline that they're required to follow. And I have no objection to giving them, until March 10th to come up with their draft scope, especially given that there's 2 holidays in between now and January 10th. Three holidays.
Depends on your faith structure. There could be more.
Yeah, that's true. At least 3.
So should we look at that in the context of the resolution when we get to it, and we can change it as we go?
Yeah, I mean, if no one objects, I'll make the change as now and before I pull it up.
Does anyone have objections or thoughts about that request?
I think it's totally fair. If the applicant wants more time to develop a proper document, by all means.
All right, sounds good to me.
Okay, so this is the resolution that everyone has received. It's a resolution to adopt a determination of significance, a positive declaration. It goes a little bit through the history of the project. All of the years of reviews and studies. Now, therefore, be it resolved that the planning board hereby concludes that the project includes the potential for at least one significant adverse environmental impact as set forth in parts 2 and 3 of the EAF, and that the applicant is directed to prepare a supplemental draft environmental impact statement in accordance with the requirements of 6 NYCRR section 617.9 and 617.12. Be it further resolved that the scoping will be conducted and the applicant is directed to submit a draft scope to the planning board in accordance with 6 NYCRR section 617.8 on or before March 10th, 2022. Be it further resolved that the planning board intends to hold a public hearing on the draft scope to be scheduled at a future date and time. Be it further resolved that the planning board secretary is authorized and directed to file this positive declaration with the city clerk, all involved and interested agencies, the mayor, the applicant, the environmental notice bulletin, and any other person who has requested a copy. And I will add that if the applicant wants an additional extension of the time, I see no reason, why they couldn't submit a letter in writing requesting that down the road. We just want a paper trail showing that it's not the board causing any delay, that it's at the applicant's request.
Thank you, Victoria. Yeah, actually, one small thing is that the planning board secretary, is that the planning board clerk? I mean, actually, in this case, it'll be me filing it. So you might just say that either clerk or chair in this case. I guess it doesn't really matter. All right, board, you all have the resolution to review in advance. Did anyone have questions or changes you would suggest for this? All right, should we take a vote? Can I have a motion to approve the resolution?
So moved.
Did you get the one, Victoria?
So I'm sorry, it was Larry who moved?
And John at the same time.
Okay, so.
Give it to
Josh-
Larry. I'll second it.
Okay. Got it.
Do you want to do a roll call vote, Victoria? Go through everybody.
Sure, Larry,
Yes.
John,
Yes.
Teresa,
Yes.
Laura,
Yes.
Eugene,
Yes.
Clark,
Yes.
and Stephen.
Yes.
Okay, resolution passes.
All right. Good work, folks. This is a big milestone getting to this point. So, Victoria, in terms of the scoping hearing, I just wanted to clarify. So, I mean, when do we do that? Is that the next step?
So once the applicant gives you a draft scope, you're going to review it for completeness. There might be one or two drafts back and forth, at which point you'll determine whether or not it's adequate for a public hearing. The timeline under seeker is that you have 60 days once the draft scope is submitted to adopt a final scope. So it will happen rather quickly once the draft scope is submitted.
Okay, once it arrives, but essentially this is now kind of off the agenda until we receive that.
Correct.
Okay.
Okay.
All right.
Mhm.
Thank you, folks. Moving on, then we have the Pocketbook Factory. Sorry, I'm just getting back to my agenda. All right. So next is 549 Washington Street, site plan application from Pocketbook Factory Hudson for mixed-use redevelopment project, including a 40-room hotel, retail, office, and gallery spaces. The site is in the GCT zone district. Okay, so I was not at the last meeting, but as I understand it, where we are is that we were reviewing a resolution for approval, and we had a sticking point basically around public access for the courtyard of the property. I know the applicant's attorney and our attorney have been in touch to discuss, how this might be conditioned and how we might reflect this in the resolution. But I mean, Victoria, would you mind maybe just providing a quick synopsis of kind of like everything from the easement to the concept of the license agreement and where we ended up?
Sure. So I'll start by saying that throughout the process, the applicant has, touted public access as part of the project. And the question was asked early on, is this part of the project? And if so, how is it going to be enforced? Which is why the planning board included a condition that there would be an easement for public access, just, as part of the routine paperwork for the project. However, the applicant did object to that condition. As a site plan review, there's no basis for the planning board to require public access in and of itself for a project like this. So that condition has now been removed, but the applicant has agreed to endeavor to provide public access. And I'm actually going to let Andy Howard talk to see if he has any updates on the issue.
Well, yeah, so what we did is we prepared a license agreement, which kind of met what we've been saying all along, that we would provide, public access for passive recreational activities, set the hours, and said that this would be a condition of our approval, and then it would be, for the life of this project, and that it could only be changed if the use changed, and either we as the owner, or if we were to sell the property to somebody else, if a new owner came with a new project, they would be back in front of you. And at that point, they could get rid of that, and they'd have to go through a planning board process to get those approvals. And in connection with that, we did include, I understand there may be a sticking point with regard to, just making sure that there was insurance coverage. And I understand that may be something that, that the city is concerned about. I mean, from our standpoint, insurance is something that's pretty standard. I mean, when people use any sort of open space in the city, be it the Little League or someone else, they have an insurance binder similar to this. That's what we were asking for. Our position was we never said we would grant an easement. We were envisioning this as either being a condition or, as we agreed, to be a license agreement. Certainly, if there was going to be if we had agreed to put an easement in place, likewise, there would be insurance in that scenario as well. And so we did create a several page document with a license agreement, and Sean Rowland's on the Zoom conference as well. I mean, we're certainly not, and we said it last week, we're not walking away from the public access component. We put in specific time and usage ability.
So the issue with the license agreement for the board, a license agreement is not an interest in property, it's permission, and it can be revoked at any time. And the license agreement as drafted, actually this one was drafted with a 30-day revocation period for any reason, but it did require the city to come up with $1 million insurance policy. And we were just concerned that the applicant was putting this additional burden on the city in order to cover the liability of people coming on the property instead of, covering it. So the license agreement is not included as a condition of this approval, nor is an easement. If the applicant wants to follow through and provide public access, great, but it's not a requirement of the project as the resolution is now drafted.
Victoria, you had said earlier that it cannot be a condition. Take away the easement, take away the license, it sounds really strange. We can't just, the idea was that the public access would be one of the conditions, and the applicant, I believe, agreed to that. So
they offered it up. They did offer it up early on. And so the problem here is that now that there's an objection, conditions of approval have to be reasonably related to some harm that the project is going to cause. And you have a project here that, arguably complies with the zoning requirements. They came in for site plan approval. And unless you can link this public access requirement, taking a property interest to the project itself, its compliance with zoning, parking issues, those sorts of things, the planning board won't have a basis to require it.
So the applicants, I have to be honest, I didn't understand all of that.
Yeah.
And I hope that everybody else did. But the applicant now does not agree to make the public access a condition?
Correct. They will. Yes, the applicant is objecting. They're saying that they offered it to be nice, but they never intended that it would become a permanent part of the project that runs with the land forever. So the way I would think about it is, I have an office and I have a parking lot and I'm in a very busy village. And so if the village said, sure, you can open up your office, Victoria, as a lawyer, but you have to let everyone in the village park in your parking lot, I would say, you can't do that. You can't make me open my parking lot to the public. So for the same reason, Mr. Rowland is now saying, you can't do this. You can't make me open my park to the public, even though it was something he proposed. But so you have to go back and think about the project and approval of it in terms of the zoning without the public access piece.
Can I speak for just a second, just to clarify? What I'm saying is that our intentions haven't changed since the first time we presented it, which is to have our courtyard open during daylight hours for anyone to come and enjoy and use. And, speaking to what Andy said, what we can't agree to is granting a property right. So we can't agree to an easement. And we never, that was literally a word that I'd never heard until the last meeting relating to our project. So that's really the objection. Our intention and our goals around, creating beautiful courtyard that's open for anyone to use are the same and will continue to be. So I just wanted to clarify that nothing is really shifted on our end from when we started talking about this till now.
So Sean, though, taking away the easement, which is frankly not something that was the first time I think the board had ever heard that term in relationship to this application. So taking away that for a second, but you still are not willing to make this public access a condition of the agreement. Take away the easement part of it. I thought that you had agreed that it could be that you were fine with it being a condition of the application. The public.
Yeah, that's the part where I got a little confused with Victoria, what you were just explaining. I don't know, Andy, like I'm actually slightly confused too. So maybe Andy can speak.
I mean, the problem is the intention is great, but from my perspective as an attorney, I have to say, how do you enforce it? Because if Sean sells the property next week and, Four Seasons comes in and builds out this hotel property, they say, we're not opening the park. How does the planning board enforce it? And so that's why we had asked for the easement in order to enforce the continued public access. But if that's no longer part of the project, then we can't ask for that.
But is it not possible? I mean, you're right, Victoria, and I see what you're saying, but if Four Seasons comes in and buys a property, they're coming to the planning board anyway with a whole new set of, issues. And how concerned do we really need to be about the potential new owner? If Sean is willing to uphold what he has said all this time, and make it a condition, as long as it's a condition of this particular usage of the building and ownership of the building, is that something that the board would consider, agreeable?
So I just don't think that's enforceable, because the way to make it a condition is to get some legal document that they would comply with. So even the license agreement might give the city some more protection, but I can't authorize the city to take on a $1 million insurance liability policy.
But why would the city need to do that, Andy? You're going to have a $1 million or $3 million liability policy. Why does the city have to do that?
Yeah, no, what we said, just so to answer your question, Laura, we did recognize that these would be conditions, and the license agreement we forwarded said that they would continue to be conditions for as long as we own the property, and that we would keep this license in place in accordance with the site plan approval that this planning board would issue. What we said in there is that the city would simply provide us with, a copy of their liability insurance policy naming the owner as additional insured. And that is something that I think the city could do. And I think it's something that organizations and businesses do all the time. And I mean, certainly that must have been something that would have been envisioned, because if we're granting a license, or granting even more so an easement, there's certainly going to be that insurance component. I mean, to me, that's a standard thing. So in terms of answering your question, we are fine with it being a condition. And we thought that, that would be part of our site plan, and it would be as enforceable as the other conditions that the board would issue.
It's not enforceable, because it's a condition, again, as drafted, it was revocable on 30 days notice.
No, it wasn't. You're wrong. That's not what it says. I'll read it. It says it shall remain in place during such time as the party of the first part, us, owns and utilizes the subject premises in accordance with the site plan issued by the City of Hudson Planning Board. In the event the party sells it and the new owner intends to continue to use the subject premises in accordance with the aforesaid planning board approval, the license agreement shall be assigned to the new owner. In the event us or the new owner wish to use the property in a manner different than the planning board approval, then at that point they could terminate it. Because if that was going to happen, there'd be a new use, and either us or a new owner would have to come back to the planning board. So we were never going to separate from you guys. We were going to keep this in place. As long as we're carrying out our use in accordance with this site plan approval, that public use would be in place.
I mean, again, it's the insurance. If they have a private party and someone falls, now the city has an insurance policy, the city is going to get sued. I'm just not comfortable including this without talking to the common council about it.
You know, Andy, any of us in business know about additionally insured. Stage would certainly use it all the time. But really, I mean, truly, can we let that go? The fact is, the city isn't inviting the public to use, you know, this beautiful space and to come and enjoy it. Your applicant has invited the public. So I don't see why the city needs to carry the insurance when we all know that the project is going to be carrying massive insurance anyway. Why should the city? It just doesn't make sense to me, Andy. The applicant, Sean, and everybody that works with the pocketbook factory has talked all this time about this being a public space. The applicant, the project is inviting the public, not the city. So I don't see why the city really needs to put the additionally insured on there. The city also, the city isn't going to say, isn't going to dictate what times and days the public can be there. The city has nothing really to do with it. Can't we make this work with the license without the additionally insured? Everybody wants to approve this project. We're one additionally insured away from making it work.
Yeah, I mean, I think, you know, the reason is the reason we need the insurance would be the same reason the city that has a lot of insurance requires it whenever anyone wants to use one of their spaces.
But
you know, it's the same. It's the
City
same
has
thing.
no control over the space.
Well, we do. We're keeping it open. We're having conditions where we're going to keep it open from sunrise to sundown. And the city, you know, is, you know, basically the party of the second part in this license agreement. I mean, we're making them a party of this. We're giving them this right. We're not giving it in an easement because we hadn't heard that. So we're giving it in a license. And, you know, usually in all the license agreements I prepare, that is something that's in it, you know.
Can I ask a question, Andy?
Yeah.
How would it be different? Say this gets struck completely, right? And there's no deal at all, but you guys state that you're going to stick with your original general premise that the public is invited in, right? So say this falls away, this, you know, the condition goes away, and you guys stick with your notion that the public is going to be there. Neighbors, whoever can come in based on your own rules, regulations, etc. How would your insurance differ in that scenario? You're still going to need to carry insurance for people using that space, correct? Whether they're your customers or the public.
We certainly will. Whether the level would be different, I wouldn't know. I mean, we haven't run that down with our insurance company yet. You know,
that sort of leads to my question is why, per Laura, and thank you, Laura, for that excellent summary. Why couldn't we have this as a condition? And the pocketbook factory agrees to cover the insurance because you're going to be doing that anyway, aren't you?
Well, we have our own insurance. The issue is making sure that the city, as the other party to this agreement, has it, or alternatively, that it's a condition of the approval, which I understand your attorney's concerned about. But I think if we don't satisfy that condition, Clark, I mean, you can revoke our site plan. I mean, we fully expect
You
to
can't
comply
have
with
a
that.
condition with no. I'm concerned about this condition because I think it creates unrealistic expectations because the condition there's no basis here for the planning board to require public access. It was offered by the applicant. If the applicant never offered it, I don't think the planning board would have brought it up. Maybe you would have, but you know, there would have had to have been a basis for it. So either the applicant, you know, fully commits to providing this access, or it's just something that they intend to do and we leave it at that. I don't want a condition that in 2 years from now, we're fighting over whether it's really enforceable or not. I think that creates more confusion, and then people will be upset because they thought, you know, they were going to have access and they don't.
So kind of, Andy, let's be truthful. You're coming up with a license saying that the city has to pay not pay, but give you an additionally insured because we can't agree to trusting that just making it a condition is going to work. So we've got it.
That's what I'm hearing now. I didn't put the insurance in to get that response. I didn't know that was going to be the response.
And I mean, when we, just from our end, when, Andy prepared the license agreement for us to review, and, we ran it by our insurance people, and just the standard, I think what Andy's saying about this just being a fairly standard practice was echoed with, the other people that we need to go to make sure that we're operating responsibly. And so it's not an obstacle that we put in place at all. It's just was the, best practices and advice that we were given if we're going to have a license agreement or a contract with the city, that we should make sure that that's done properly and, for everyone's protection, including the city's, not just for ours. And so that to answer your question, Laura, that's where we're coming from. It wasn't an obstacle that we put in artificially.
It feels like you're asking the city now to subsidize your intention to give public access to people. And so, again, my recommendation to the planning board is to leave out the public access condition altogether, and let the community hold them accountable for providing access or not, because
or not vote in favor of the project. I mean, this is the fact that who is the public? If the city, which they will not do, I doubt, wants to take the responsibility of giving an additionally insured, then who's to say who's the member of the public? Who isn't a member of the public? Somebody that's visiting you and staying in your hotel is a member of the public. So this is just way too complicated, and I certainly wouldn't blame the city for saying no to the additionally insured. So we've just made something that should have worked very, very complicated. And
can I make another comment quickly, just sort of a thought exercise? Like the individuals coming in, you're presuming the individuals coming in, clearly they're citizens of Hudson, correct? But you're saying because they're citizens of Hudson, it's Hudson's liability question. If these, again, just sort of throwing this out there, if these people invited in, individuals happen to be citizens of the Hudson, are your guests, you're inviting in the public. And again, you're presuming that they are somehow should be protected by the city of Hudson. Why wouldn't one, again, thought exercise here, couldn't one presume these people, who of course happen to be citizens of Hudson, are now, as they enter your space, your temporary guests, and clearly you have plenty of insurance for temporary guests. So, which are really all of your citizens. So again, I'm a bit confused on why the Pocketbook Factory is now assuming the public or individuals in the city of Hudson are now required to be protected by the city of Hudson's insurance.
Well, because we're granting a public access license and the city is a signatory or, is a grantee of that. And so, really it would be in the city's interest, because getting that in a license agreement, regardless of us, we're the owner. If somebody was injured and wanted to bring a claim, the fact that we do or do not have an insurance clause doesn't mean they may not name the city. And so prudence just dictates that we have it. And from a cost standpoint, I don't think it'll cost the city anything more. Again, it would be an additional insured certificate. Like, as you said, Laura, that's something that you obtained all the time. If you went to different places, you didn't pay more for it.
No, but what we're talking about is now you get down to defining who the public is. So somebody that is a guest at the hotel or goes shopping in one of the shops is a member of the public. And so there's an accident or something happens and the city is now liable because who's going to define public? Is it the person sitting there having a sandwich on their lunch break? But it also could be the person that's staying in the hotel or the person that went shopping and decides to sit down and smoke a cigarette and have a cup of coffee. So everybody's the public. And why should the city, you can't distinguish, this open space. And this is, I have to say, this is misleading based on conversations that somebody just wrote, held with the community. This is so far away from the spirit of what was offered.
Well, we have, again, again, I'll toss this to Sean. I mean, I certainly think it would be in the city's interest to have that. We haven't changed anything with regard to the public access itself. I mean, if the applicant is comfortable not having that in there, I mean, I think we could remove it. But just to be clear, Laura, this is a standard agreement. This was not done to somehow torpedo the license agreement that we drafted. I mean, that is just not how these things are handled. And if the city doesn't want that protection, then, I think maybe, we can talk about removing it.
The difference is the city has insurance over city property. This would not be a property that the city owns or has any control over. So insurance, it's not as simple as just getting a certificate of insurance. So because it's not city property, the city has no interest. So that said, though, the Common Council would have to approve of any license agreement. So it's not something that could be resolved tonight anyways. And I continue to stand by my recommendation that, the board drop the public access issue and, leave it up to the owner to provide access themselves if that's the commitment they've made to the community.
And I guess my response to that would be that continues to be our intention. And I would welcome members of the public or any of you to come when we're open, and the gate will be open. And I think that, that isn't going to waver. And I do think there's an amount of, trust and rapport and vision in what we've talked about together here for a really long time. And, I think, honestly, now I didn't even realize that we would have to go to the Common Council if we do a license agreement. And frankly, we're really eager to get started with our project, and it's consistent. And I think we'll continue to be so. And the vision is there, and we're very much out in front of the public in Hudson and are being held accountable by members beyond this board to sharing that vision. And, both sharing and participating in what community members and leaders are bringing to us. So I guess, Victoria, I appreciate your recommendation because I think it recognizes that there are other mechanisms beyond this board to hold us accountable for our intentions and our words within the community.
There's not, is what Victoria is saying. So board, there's not.
So I guess, what's before us is basically, as I understand it, I'll see if I can get this correct, right? I mean, so one, we can't do an easement. We don't have the power to say that they have to do public access on their land in any way, right? So that's completely off the table. This license agreement, if we were to make this a condition, it would require approval from the city council, and they would have to do this added naming of pocketbook factory in their insurance, which I mean, it's, it's been presented as something that maybe would be easy. I think the likelihood of that happening is zero. That's just my read on it, but I don't see that happening, right? So, so the question is, I mean, we don't have the power to say they have to grant public access. It's their intention to do so, as they've stated. Is there anything that we can speak to in a condition that just, while it might not be enforceable, that has any meaning, just to speak to that intention? That's essentially what this conversation is about, basically.
Well, I did put it. Oh, sorry, Larry, go on.
Well, I just think, the options in front of us are to refer to the Common Council to see whether they indeed want us to be clear about having the stipulated condition in our site plan approval, and do they agree? Are they willing to actually take on the additionally insured? Or do we simply take Victoria's advice and recognize that we have some good intentions by the applicant, which they may have simply stated in order to win over public approval, that's not enforceable, and we have to do our best to trust that they're going to do that. If they don't, we have no mechanism for holding them to it, and that's just the nature of life. That they told us one thing, in fact they're going to do a different thing, but at the end of the day they didn't have to offer this thing, so we can't really get all that mad at them for taking it away because they were only doing it to win good favor, and that's not actually in play now. And it seems straightforward, right? Like, if Steve, you're hesitant to refer to the Common Council, then I think the issue is, for the board, do we want to accept the project with good intentions from the applicant and no enforceable mechanism? I think that sounds like 2 votes if you want to hold 2 votes. One vote might be the referral to the Common Council for the license agreement, and then another vote that accepts the project without the condition.
I think that you bring up a good point, the one that I silly didn't think of. Why not see it, have it proposed to the Common Council? The Common Council says no, then, then we know that we make it a condition that is most likely not enforceable. And then we vote on it. But let's see, why not give the Common Council the opportunity to consider this? Can't hear you, Clark.
Right. It's a price tag issue, isn't it? Right. The concern about the Common Councils are going to say, well, this is too much money. But
it's not really going to cost the Common Council anything because it's an additionally insured and so, well, actually, is that true that additionally insured doesn't cost anything?
That's on your own property, right? If you own property and you're letting people come on and have a wedding, you can add them as additional insured. But this is someone else's property. So I'm not sure that it doesn't cost anything because the city has no control over this property. I can't answer that question. But again, the license agreement as a condition is unenforceable for the same reason as an easement because it's requiring public access. If they want to offer the Common Council a license agreement, great, let the Common Council, decide whether they want that or not. But I just.
But that's separate from what we're doing here.
Yes.
It is? So it's no longer a condition?
No.
I see.
Wait, sorry, Victoria, can you explain that? Because I thought that if we made it a condition, well, I guess you're saying we could pass a resolution with that condition and it would just rely on the Common Council to have to review it and approve it. And if it's not approved, then that condition just goes away, basically.
And then they don't have approval and they have to come back to us. Or what? Like what?
Okay. So, right, I'm saying that requiring public access, whether it be by easement or license agreement, is the same problem. You're requiring public access to the property. However, if the applicant volunteers to allow this as a condition, we could draft it in such a way that we would be requiring a license agreement. So evidence of an executed license agreement with the Common Council. If Common Council votes to not execute the license agreement, this condition is null and void. Something to that effect, so that the condition is only relevant if the Common Council moves forward, but it would require them to ask the Common Council.
But could there be then a second condition that says that if the Common Council says no, then at least we put the condition in there that says that at least, they had said all along that this was the public was invited. And if they don't do it, then, frankly, there's so many wonderful places in Hudson. I hope that everybody remembers all the great locations that we have here to go sit and have a cup of coffee. The applicant, the only reason this is a discussion is it's because it's been the focal point of this application is been this public access.
Right.
Right. So what I did was I added this language to the resolution. It's whereas after the public hearing, despite having touted public access as a project amenity, the applicant advised the planning board that it would not consent to a permanent easement allowing public access to the property. And whereas the applicant has stated it will nonetheless endeavor to provide public access to the interior courtyard of the property as shown on the site plan set. So, the resolution acknowledges that they're going to try to provide access, but that's it. So it's in there. People can go back and see that was the intention. But
can I ask a question or make a suggestion here? Can we suggest that, outside the planning board's approval, and I appreciate those comments, can we say in that whereas that the applicant has agreed to pursue a license agreement separately with the Common Council?
Andy, is that an accurate statement? If we're not making it a condition, are you still going to pursue it?
I mean, I'll have to talk to my client. I think, to be clear, going back to Laura's comments, I mean, we would be comfortable having this be a condition. I know, Victoria, you have some concerns about it, but I want to make sure that this is conveyed accurately to the public. I mean, we are not backing away from the public access, and we would be comfortable with this planning board making it a condition. Because we've been working with you, and you're right, we've made these representations, and Victoria has properly referenced that it is in our site plan set. We're intending to keep it in our site plan set. You know, and that's why last week we said we would give this sort of agreement, and we're not changing that, and we're not trying to hold it up, but we do want to try to have some finality on this. And you know, if your attorney's telling you it's not enforceable either way, what we're saying is then put it in our approval, put it in our condition, or our site plan approval right now, so that you have that condition as a board on us as the applicant, so that there's privity between us. And that seems to make more sense because you guys have been reviewing it. So we're in front of you and we're telling you what we're going to do, and you're telling us, yes, that's a condition of what we expect you to do. And we're not moving away from that at all.
Victoria, do you have any language with about the form that condition could take if we include the license agreement?
Let me see.
Could drop in and look at that quickly.
Okay, just give me a minute. Let me think about it.
Yeah. And Victoria, if you look at, just for an example, if you look at 1 and 2 of the terms and conditions on the license,
I mean, again, if you're offering it, I think that's great. I just don't know why it needs to be incorporated because.
well, because it seems like the board wants to make sure that we're being, acting in good faith, and we want to have more than just words. We're willing to have it in the approval.
I'm so confused, but Victoria will explain it.
I'm not sure I understand either. The problem is what they're offering is not saying that they're going to open up to the public. They're saying we're going to give the city the right to open this up to the public. But the city, it comes with obligations. The city will now be, a licensee of the site. And so the city has to accept that. And that's sort of what I'm struggling with.
I'm sorry, what I was thinking in terms of conditions would be that the courtyard space would be open and available to members of the general public on a daily basis, beginning 1 hour after sunrise and terminating 1 hour after sunset. Like us providing on our property, this is the public access that we will provide as a condition, that you're requiring that.
Right, but Andy, so let me just go back to what my.
That's what we've always said.
Because,
that's.
Right, you've said that, but then when we asked you to back it up with a legal document, you said no.
We heard for the first time that you wanted an easement, and then we had a discussion and said we do this written agreement, and we did it.
No, because when we put it in the resolution, right? And then when another person buys the property, they say, we don't like this condition, it's not enforceable, it's a taking. And then then the planning board's in a position we don't want to be in down the road.
Well, but if that happened, wouldn't they have to come back to the planning board for a new approval? So then you guys you could ask them to do the
your
same
approval
thing.
runs with the land. So if they buy your project and don't make any changes that require a new site plan, they don't have to come back before the board.
Victoria, I so appreciate you, really. I've learned so much. Just let me ask you, just in terms of this application as opposed to what happens in the future if they sell it, is there a way to word it as a condition for the purposes of the Puck factory as we know it now, that would obligate them to do what Andy just said, 1 hour before XYZ and 1 hour, whatever the time frame is that he just said? Is there a way? Are you saying that even if we put the condition in worded the way Andy's just said, they're still not obligated to do what's in the approval?
I'm saying they could challenge it down the road. they or a future owner as an unenforceable, a constitutional taking of their property rights.
But they just agreed to it.
I know, well then, okay, so let me see what I can do with this condition. Just
Okay.
give me a few minutes. Do you want to go to the other one while I think on this?
Yeah, I mean, should we review just the rest of the conditions in the resolution in the meantime?
Sure.
Well,
Here, let me
why
pull it
don't we,
back.
hey, guys, why don't we take a 5-minute break? Because I actually could use one. Because I don't want to look at the other conditions about Victoria. Right?
Well, I mean, I can go through the conditions with you and then I'll take a break, but.
Do you guys need a quick break, or do you want to do this?
Steve, is this the last item on our agenda?
Yes.
We have a short, with 26 Warren Street, actually, we'll open the public hearing again so that we don't have to renotice that one. And if anyone wants to make a comment about it, but that'll be the only portion of that one. So there's a small bit at the end, but otherwise this is it.
And so we're not going to take up a resolution on 26 Warren tonight.
No.
It's going to continue the public hearing.
Yeah.
And why is that?
So that we don't have to renotice it, basically. I mean,
Right, but why aren't we doing it tonight? Don't we have?
The applicant doesn't want to.
Yeah, the applicant requested that we move it into December, actually, because they weren't able to join tonight.
Why don't we take that 5-minute break now? Because I could use one.
Okay.
All right, Laura, well, let's come back at 7:30 if we can.
Okay. We
Okay.
will.
Bye-bye. Let's see.
Or Victoria doesn't get a break now.
right, I'll give everybody a minute to come back. Victoria, are you back?
Yep, I'm here. Hey.
Hey, all right, so should we look at the resolution?
Yeah, let's go through it and then we can go to the other one and come back to this.
Okay.
Or we can come back to it another night.
I mean, I'd like to try and see if we can get through it tonight if we can. So let's take a look.
Okay.
Victoria, would you rather postpone?
Well, I mean, I guess it depends on what the board ultimately decides to do. I don't want to put the city in a position that I'm just not comfortable with yet. So here we go, Pocketbook Factory. These are the whereas clauses, which explain a little bit of history about the project. It went to review. You adopted a seeker determination on October 14th, 2021. And by the way, I went back and looked at your negative declaration, and there was nothing in there that really relied on public parkland. So it wasn't part of your environmental considerations.
So what does that mean though, Victoria?
Oh, it just means that like if you had put the parkland in as mitigation for something, then we would have to go back and, you know, reopen SECRA now that it won't be open. Then I put in those two paragraphs. Okay, so let's go through the conditions as they are now. 1, payment of fees in escrow. 2, revision of the site plan set to include the following note. Applicant or authorized designee shall provide off-site parking facilities and a shuttle for events more than 75 people. And that they have to file proof of the availability of off-site parking in the form of a written lease or other agreement at least 10 days prior to any event of more than 75 people. Failure to provide the proof shall be violation of site plan approval. So the way that this is drafted doesn't require them to get a long-term lease of a year or 2 years anywhere in particular, but it does require that they get it every time they have an event. So it could be at location A 1 month and location B another month, as this is drafted.
Didn't we say 40 people or something like that?
So the next one has to do with the 40, Teresa. We are requiring them to get 40 parking permits on an annual basis from the city for their guests and employees. So the first condition has to do with the special events. If they're going to host a wedding, they need to have some kind of off-site parking for all of those additional guests.
But we had said that if they bring in 75 people in that area, that is going to be devastating to that area. And I think we lowered that number. Does anyone else remember but me? I thought we lowered it to 40.
That's my memory as well. And I think that Patrick did that.
Yeah, we did. We lowered that to 40 because 75 people in that area is a lot of people, a lot of parking, a lot of cars.
You're saying
Okay.
that, so I see what you're saying. We did lower that to, I don't remember that it was 40.
It
but
was 40.
So for private events of more than 40 people, they have to have off-site parking and a shuttle?
We lowered it, yeah.
And
Mary,
did-
do you remember what we I think it was 40.
I believe it was.
Yeah.
I think that the point is that, let's just say that an event has 65 people. Now they're not required to have the off-site parking, but 65 people will devastate that area.
75, 65, 40 was devastated.
Did you guys run this by your planning board engineer? Because I thought the review that he had did was based on this concept of 75 or more, right?
He was here he was at
Okay.
the meeting because we're talking about that's 40 extra. You know, you got 40 people staying in a hotel. then you have an event, you're bringing in another 40, or 70. So we're talking, they lowered that number for events. And I remember 40.
Okay.
May I ask a
Or
question?
41 or something like that. I'm sorry.
Well, can you
Chair, may
look-
I ask a question?
Go
regarding
ahead, Sean. What's your question?
What happens if the event is like already for people staying at the hotel? Like they're already there.
I think that was like 41. That's why I went to 41. I think it was 41, just in case there are people in the hotel, then one parking space over, then you just shuttle them in, something like that.
Sean, what's the hotel capacity?
40 keys, so 80 people. But my question is sort of like, what if people are staying in the hotel and then they have an event and their cars are already parked there? This, how it's written now, I think would mean we'd have to do a shuttle for people that were already there and already had parked just within the normal capacity of the neighborhood.
No, this is an addition to the people that's staying. That's what I took it as.
That's a good point.
Right.
I guess we have to clarify that though, that this would be a condition.
we have to
So
clarify
yeah,
clarify that in the
I think
way.
that seems reasonable.
Yeah.
So
Yeah, let's clarify it.
not including hotel guests?
Not including a private event.
Yeah, private
Or
event.
excluding hotel guests?
Yeah, excluding hotel guests. That's true. So put the 40 back.
Including private events hosted by the hotel guests or not hosted, but
Take it 40 and put excluding hotel guests in parentheses.
That's it. Because that means that 40 people are going to be there already. So now 40 more can come after that. You have to start, find another way to get them in.
that's
Yep, that's good.
Change that 41 to 40.
So, I mean, if you're doing this, I just want to understand, you should make findings that it's due to this project's location near a residential neighborhood, because
Yes.
there's restaurant and brew pubs and other places that are going to routinely have more than 40 people in the city.
Yes, this is because of where they're located. They're located on the corner of almost an exclusive residential neighborhood.
and also they unlike other businesses, they have 40 hotel guests there already.
So
right. What we're talking about is after that 40 that the people that are hotel guests, 40 more people in excess of that so however you want to put that.
Okay, I mean, and we're having them, so if you look at 3, they're going to buy 40 parking permits for the hotel guests and employees.
Right. So this is in excess of those 40 people.
Yeah, that's clear and fair.
Or should we look at 4 then?
Hmm?
Applicant shall operate a shuttle to the project site for construction workers during the construction phase of the project. In the event the applicant secures fixed parking spaces totaling at least 40 spaces, the applicant shall not be required to operate the construction shuttle.
So the question I have here is, does the 40 annual permits from the city, would that satisfy this fixed parking space?
No, because I think the applicant won't have those 40 spaces until after, right, Andy? They're not going to even have those spaces, those permits until after the building's completed.
Correct.
Okay.
And plus, you can't really park big trucks in the. Yeah.
Right.
Applicant shall submit a sound attenuation plan to mitigate noise impacts from outdoor events and demonstrate compliance with the City of Hudson noise ordinance. Form of and substance of which shall be approved by an acoustics engineer or consultant to be determined by the planning board. And then it, ongoing, it must comply with all regulations. So the way that these are drafted is these conditions have to be met before Stephen signs the plans. So it's before a building permit can be issued. So then if you go down,
How's that so?
before the building permit, now they have to show that they have the construction spaces. And then before a CO, they have to show that they have the 40 annual parking permits from the city.
But I think there's one missing. I thought that in the last meeting, it was discussed and we also got another letter from a member of the public that in terms of amplified sound outside during the week, I think they're allowed to end that at what time, guys? 10?
Says 9 p.m. on Sunday through Thursday.
Yeah, I think it's in there, Laura, and at the very
It's right, it's here.
Well, no,
Yeah.
I know, I see that, but because it was brought up, and then again, if you guys read the letter that we received, it was brought up that during the week, people have children and they need to go to bed and get up in the morning to go to school. And so I thought that, during the, Monday, Tuesday, Wednesday, Thursday, we had said that the amplified noise needs to stop before 9 p.m.
I think we voted on that. So the code says 10 p.m. and we went back and forth between 8 and 9. We voted and we decided it was 9.
Okay.
In some sense, there has to be an acknowledgement that these people bought property near a commercial site.
But the people were there. This site has been closed for a long time. And when it was open, it wasn't doing what they're doing.
That's true, but the zoning always allowed it. And so there is some obligation on, someone always takes a risk when they purchase near a site zoned for commercial. And so, we have to weigh the rights of the applicant with the rights of the neighbors and balance those.
Understood. Okay, so where are we, Steve?
I think the lingering question is just about do we take this in its current form, or do we try and add something about the license, basically?
Well, or a condition about the open space, the public space.
Look, I think given, my own opinion, and I'll defer to others here, but my own opinion is that publicly granted open space on private property is at the will and discretion of the property owner. They said they were going to do this thing. We have no mechanism or means to properly hold them to it. I don't see any reason to actually try to figure out a back door into having them do this thing that they, may or may not do. It would be nice if they did it, but at the end of the day, they don't have to. It's their property. And, I think it would have been nice if we could have figured out a way in which we secured public access, like I said last month, or whenever that was, kumbaya intentions are not enforceable. They weren't then, they aren't this month either. And, it seems to me that we don't have a mechanism, we don't have leverage. If they wish to grant it to the visitors to their property, great. If they decide to change their mind, that's a pity. But, if we don't like it, we don't have to buy their fucking $18 mojitos. We go somewhere else for our mojitos.
I don't understand, Larry, how we got there. Victoria hasn't given up on, there's nothing to say that we can't make it a condition of the agreement here that they have said that this is going to be a public space and it's a condition.
Well, we could make it a condition, Laura, but as I understand it, to Victoria's point, it just wouldn't be enforceable anyway. So we could certainly put that in there as a condition. I just don't think that we could, like the goal of the license, I think, is something enforceable, but.
She said it might not be enforceable because they could turn around and say it's a taking, but they basically indicated there's nothing that they have done that has indicated that they would turn around and say that this is a taking. I have a trust issue But even I trust that if we put it there, that at least in this form with this particular owner and this particular attorney, they're not going to turn around and say it's a taking and sue whoever they would sue.
So what I think it's actually helpful to go through and let everybody have a chance to kind of see where they're at like this. I mean, I think like Larry, it sounds like it's in favor of let's review the resolution in its current form for a vote. Laura, I think you want to put in a condition, basically not necessarily about the license, but something speaking to the fact that they'll provide public access to the court.
Clear. I think that we need to put the condition in there and not worry about the taking. And if they, if they do this taking thing, then frankly, the community will think that they're jerks.
All of vote, Steve.
I think that we should start, just let me finish. I also think that they should be given the opportunity. So there's that. And then also they should be given they should have to go to the Common Council and see if they'll do the license. The council will agree to the license. But if the council says no to the license, then we have this condition.
Okay. I think that makes sense. So Teresa, what do you think?
I want to follow the way of Victoria. Whatever she suggests, I'm going to follow the attorney's suggestion on this one.
Sorry, Victoria, you had a question?
Oh, I was just asking, Laura said, go to the Common Council. If they say no, we have the condition. What condition is that?
Well, the condition that they have a public space from X time of day to, X time of day. I mean, it would be worded better than that, but this is what they have been, some form that says that all the way through the application process, one of the biggest things that they've talked about is this open space and bringing the community in, and they want to, be friendly with the community and accommodating the community, that we put all that in there and say, and therefore, the applicant has said that they will, that the applicant needs to, adhere to what they had said. It's a public space starting at this time and ending at that time. I think that that's
right. But if it's a condition, that means that something will happen if they don't do that. And we have no means or mechanism for making them do a thing that they're doing on their own volition. And that's the problem.
I'm going to make a suggestion. Sorry. I'm going to make a suggestion which I think resolves the problem, if I may. I think we dropped the condition, and I think Larry's point's right, but in the whereas we say the applicant agrees, and we can just punt this to the Common Council. Like we say, we appreciate the fact that the Kumbaya statement is, you believe it and we trust you. And if they, we basically make a statement in the whereas saying they will appeal to the Common Council to make this license agreement happen. And then it's up to the Common Council and the citizens of the area and the citizens of Hudson to, pressure their council members or not to make this happen.
But wait a minute, I'm sorry, guys. Victoria didn't say that there's no mechanism to, I don't think, that to make sure that they that they follow the condition. What Victoria said she was worried about or concerned about is that they could say it's a taking. But I go there and I have with my cup of coffee that I bought somewhere else, with some friends, and we sit down and chit chat, and then somebody comes over and says, gee, you can't be here. And I go, well, yes, I can, because this is a public space from X amount of time to X amount of time. And then they say, well, you can't be here because we're not doing that. Well, then can't I then, what? Can't I call code, or can't I tell the board that they're not living up to the agreement? There's no mechanism if they say get out.
So wait, Laura, let me ask Victoria to clarify that thing about the taking, maybe, and then let's hear from Jean and John too about where their thinking is on this stuff. Do you want to speak to that, Victoria, about what you meant by the taking claim?
Sure. So following up on that, Laura files a complaint, and Craig goes out and writes up a notice of violation that says you are obligated under the terms of your site plan to let the public on your property. Then we take them to court. And now their defense is that you can't make me have the public on my property. And then now we're in a situation where we're trying to enforce this. And I think it's hard. I just don't think.
I see. Yeah.
But even though they agreed to hey, guys, we're giving up everything, but you know.
Hang on, Laura, though. Let's go through and hear from everybody
That's
before
all
we.
right. Even though, Victoria, they've agreed to this, they signed the thing and agreed to this condition. And in fact, invited this condition.
So, well, we're right, that's the thing. We were following through with requesting legal paperwork to go with what we thought was the project, right? To make it enforceable. They came back and said, well, that's not actually the project. You're just supposed to be reviewing this as if it's private property, but we will voluntarily offer to give the public some rights to come on the property, limited conditions, limited terms. So that's fine. I mean, you have to review the project under the terms of the zoning law. Does it meet the requirements for site plan approval or not, as proposed?
Yeah, and I mean, I actually thought Clark's recommendation was worth considering. We make it a whereas statement that they're going to seek a license agreement with the city. It's not a condition necessarily, but that, that's there, right? So we're not kind of setting this thing up to be problematic down the road. Gene, what's your thinking on this?
You sound, yeah.
Just as I stated the last meeting about this, it's private property. How can we mandate that the public is allowed to enter the property at will? They've agreed to allow the public there, as it's stated in the site plan, and the problem with the city is, that's between them and the city. Putting in a stipulation or a condition that they negotiate with the city for the insurance coverage, well, that's fine, but is it going to be enforceable? And what happens if they don't come up with an agreement? Do they have to come back to us? Does it negate the resolution whereases? I agree with Larry that the resolution written as proposed tonight is satisfactory, and I'll go along with the resolution as written.
Thanks, Gene. John, where are you thinking on this?
Well, my thinking is pretty much along the lines of Victoria, Larry, and Gene. I think adding another layer to this, I have to think that the city won't want to indemnify private land in any way. So I think that'd be, climbing up a tree that you can't get to the top of. And I think that it's just, there has to be at least some small level of trust on our part with the developer to trust that they will do it. And I think just a simple statement, in the conditions saying that, again, I don't have wording, but saying that they will, to the extent possible, allow the public to use it would suffice. And, as far as enforcement goes, that's just I think it's a tree that people don't want to climb. I just don't think it's worth it to go that route. So.
Yeah, I mean, I suppose, just to say quickly, I suppose I think I see things in a similar way to John and Gene and Larry on this one, and I believe Clark as well. I think essentially I still think it's an interesting question about whether the whereas statement can speak to this, pursuing this license, because I guess, Victoria, tell me if I'm wrong, but would that be something that could come back and, become a problem in the approval if it's a whereas statement rather than a condition?
So the whereas statement is just reciting the facts. And so the fact would be that they are going to offer this to the Common Council. It doesn't require the Common Council to accept it. And I guess if they don't offer it, it's not binding either.
Yeah.
Well, it's a recommendation and a referral, and I think that's the best that we're going to get, frankly. I like Clark's notion that we that we endeavor to work with the applicant to find a legal mechanism to ensure the open space. That's not within our authority. We highly encourage the applicant to approach the Common Council to draft a letter of agreement, but we can approve the site plan in the sense that the applicant will follow up on their own, past statements and generate the goodwill, retain the goodwill that they generated through this process. And, we hope for the best.
Yeah. I mean, I think it can be very simple. The applicant agrees to pursue a license agreement for public access to the space. I don't know if that's too simple, but yeah. And then
What do you think?
it becomes.
Yeah, what do you think, Victoria? Can we look at that on the resolution?
So hold on, what if we do something like, Sean, while we're looking at this, I just want you to understand, you said you wanted to get moving, that there's still going to be some time involved in getting the sound attenuation plan, submitted and approved.
I can't understand you, Victoria.
Yeah, I know there was feedback. I was just noting that they still have some work to do with the sound attenuation plan, and that could take some time for them to prepare and submit and get reviewed and comments back. So, they had indicated they wanted to get started with construction, and they're just, not there quite yet.
So
Understood. Yeah, we have someone lined up for that, and we'll be expeditious in getting it to the board to review.
Okay, let's see.
All right, so Victoria will share her screen in one moment, and we'll take a look at this new whereas statement. And I think we're likely ready to vote after that.
I mean, what if this is just simple. So here, I just added another resolve clause that the planning board acknowledges the applicant's intention to provide public access and encourages it to work with the Common Council to, I don't know, provide such access.
No, to draft a letter of agreement, affording public space or allowing public access.
Okay.
encourages, now I'm agreeing with everybody that says don't even bother putting anything in.
Well, can't we make it a little firmer there, saying?
No, we can't. No, you guys got what you wanted with this. This is
Go ahead, Clark. What do you want to say?
I was let's see, acknowledges the applicant's agreement to work with the Common Council to enter into, and you realize agreement is used twice, into a lease deal to allow such access.
Well, not a lease, because we don't want to pay
Okay,
for it.
so sorry, sorry, I apologize. License agreement, whatever that might be.
I mean, I'd rather just say agreement.
What does that mean? What does that mean?
It doesn't mean anything, just acknowledging that they have good intentions, but.
Yeah.
Right.
I mean, they can allow access without the license agreement.
And we're going to.
That sounds good.
Yeah.
All right. So if we're happy with this, is there anything else, or do we want to make a motion to approve the resolution?
I mean, I guess I just want to say that, Laura, I do understand why you're frustrated, because it does feel sort of like a bait and switch, but we're bound by the zoning law. And so we have to review the application in accordance with the zoning law. And that's.
And this, Victoria, no matter what, I don't see what the negative would be with having a condition that says exactly what the applicant had already agreed to. Whether it's enforceable or not in the long run, I don't see what would hurt. The applicant agreed to, and it might have even said that they more or less wrote the thing, that part. I don't see where it hurts us to put it in there.
Well, my concern was that it creates unreal expectations, and then it creates a problem for the city down the road.
I don't see where it's a problem for the city down the road. I just don't. If the applicant signs this and says that he agrees with this, I don't see how they would turn around and say that it's a taking when they actually are the ones that came up with this condition.
Right, but the problem is with the condition is that if they don't follow through, if they like, if you give me 2 hours, I'll give you 4 pieces of bread, right? That's a condition. But in this case, if they decide, you know what, no, I don't want to give the bread anymore, then I have no leverage. I have no mechanism. I have no means to actually get them to do what they said. And then they prove that they were just frankly bullshitting, but that's what it was. And we all feel raw and burned by
I would rather trust that they're going to do what they said. Andy, could you speak to this?
Well, again, I mean, we're willing to agree to that condition because that's what we're going to do. I mean, I understand, Victoria's concern. But just to be clear, we intend to provide the access that we proposed.
I guess my take also is that if we, Laura, and I respect your concern about all this, but I feel like if it's in there or if it's not, and if it's in there, it's not enforceable.
Right.
We're the same.
There's no difference, right?
We're trusting them.
Andy, is it not enforceable?
Without a condition, and we're trusting them to do it if an unenforceable condition is in there. There's not really a whole lot of difference. I would say there's no difference.
So can I just ask Andy, is this not enforceable?
I mean, I'm not going to, you have to get counsel from your attorney. I don't want to.
That means it's not
impede.
Okay, so it's not enforceable then. All right.
But if we say in good faith, you go to common council to get a license agreement, they can say yes or no. We've done our best to make that happen. I think.
Yeah. All right. So do we have a motion to approve the resolution?
Motion, so moved.
I'll second.
Larry, second by Clark. All right. Larry, your vote.
Yes.
John.
Yes.
Teresa.
Yes.
Okay. Laura.
No.
Yes.
Jean. All right. Clark.
Yes.
All right. Yes for me.
Thanks, guys.
All right. All right. Thank you, everybody. So, yeah, I mean, I guess Sean and Andy will be in touch about getting those things that we need before I can stamp the plans and everything. I'll file the resolution tomorrow, share a copy with you guys once it's filed with the city clerk. Yeah, we'll go from there. But congratulations on your approval. And yeah, thanks for your participation in this process over many months.
Thank you all very much. Thanks for all your time and consideration. It was a long, interesting journey, and I'm really glad we made it. So thank you all for your service.
Yep, thank you.
Thank you.
All right, thanks, guys. All right, so we already started to talk about this. We have one public hearing on our agenda tonight. The applicant is in fact not here. We're not going to get into reviewing the resolution, but we do, just as a matter of process, want to reopen the public hearing. And if anyone in the public would like to speak about this application, we'll create an opportunity for that now. So can I have a motion to reopen the public hearing for 26 Warren Street?
So moved.
So moved.
We all woke up at the same time.
We'll all second it too.
Lisa, who'd you get first? Who made the motion?
I did.
All right, we got Teresa. Who's second?
I'll second.
All right, John. All right, all in favor?
Aye.
Aye.
All All right, so is there anyone, any members of the public that would like to comment on the 26 Warren Street application? I'll give folks a chance. You can use the little hand raise icon.
Steve, maybe you want to review what it is? Maybe someone who is here for the first time?
Sure, that's not a bad idea, Teresa. I mean, basically, this is a site plan approval for a change of occupancy for 26 Warren Street. So it'd go from R3 to R1, which changes the use from single family residence to a hotel. And the residence has been used as a B&B basically in recent years. So yeah, I think that, you know, what we'll get into at the next meeting in our resolution is a lot of what was discussed at the last meeting around the availability of someone, you know, being on call essentially to deal with any issues that arise, since it's going to be an unstaffed hotel. But yeah, we'll get into that in more detail at the December 14th meeting. It doesn't look like we've got anybody that wants to make a comment from the public on this. So I guess, could I have a motion to continue the public hearing to our December 14th meeting?
So moved.
Thanks, Larry. Second.
Okay.
Got Gene. Thank you. All in favor?
Aye.
All right. All right. I think that's it. Any other comments, anything from the board before we adjourn?
Yeah, I had one question, Steve. I got a message asking where the parts 2 and 3 are located on the city website. If the public wants to access our documents, how do they do that?
Yeah, it's so basically there are full on the planning board webpage. You can look and click on a link that says current applications. And basically they're all organized by buckets of years. And then within each year, there's, you know, folders for each individual project based on address. Now, the Colorusso application is in the 2020 buckets. So everything that we reviewed tonight, you know, part 2, part 3, and then the resolution is all posted in you have to go to 2020 and then to 175 South Front Street. And then within that folder, you can see those 3 documents.
Got it. Okay, thank you. Are we moving to adjourn?
Can I have a motion to adjourn, Mr. Cody?
I'll make the motion. And Larry, no, I'll second it. Larry raised his hand first.
Oh, wow. You're changing. All right. So, John, we got a second from Larry. All in favor?
Aye.
All right. Thanks, everybody.
Thank you.
Take care. Thank you, Steve.
Okay, bye-bye. Thank you.
Again, welcome back.